I mean, I guess first and foremost, this is a sort of a very much a working progress. What I want to talk about today, my paper has shifted as well from my abstract, same as Nathan. So I guess in many respects I've targeted something a bit more narrow rather than the slightly broad outline that I gave in the abstract. And what I really want to focus on today is the question or the problematic, if you like, of performance. So really, rather than tokens of equity, as the name of my paper, this is really going to be looking at distributed ledger technology as performance engine. So that's kind of perhaps a more relevant title. And just my sort of final caveat before I start as well is that I am integrating certain sort of language from computer science here, and I do so with all the naivety of someone who's not a computer scientist. So any computer scientists we have, or anyone who's far more drilled in the language, apologies now, and I hope I'm using it at least with relevance, if not absolute accuracy. So I want to discuss the idea of distributed ledger technology, what I'll refer to throughout now as DLT, which encompasses blockchains, which are a species of DLT. And I want to think about and discuss them as performance engines. So I'll define performance engine for the time being, at least, relying on the emerging concept of DLT, or blockchain operating systems, that enable transaction processing to occur on cloud-hosted blockchain-based data centers. So if we consider a blockchain to be a ledger deployed as a transaction processing engine, as a component of a DLT operating system, a performance engine is the assumption of an equitable or quasi-equitable state based on the enforcement and conditioning of counterparty promises and transactions. To put it another way, DLTs recreate equity's emphasis, or rather my wager, if you like, is that DLTs recreate equity's emphasis on performance in several areas of operation, including, but not limited to, smart contracts. To go still further, we might speculate on this equity-like function of DLTs as one possible response to the question of how control exists after decentralization. And this is a reference I borrow from Alexander Galloway's book, 2004 book, Protocol. But I also kind of developing that theme a little bit. I'm also interested in how control endures within distributed networks with shared protocols, but no other meaningful or enforceable points of contact. That is, potentially no interoperability. And I'm going to return to this a little later on. So equity's long-standing remedial stake in performance, where we find a discrimination within classes of obligations that exceed the remit of the common law, meaning money remedies replaced, as Sarah Worthington says, quote, by orders that the defendant do something, end quote, is thus taken on, or mimicked perhaps, by DLTs that are capable of providing equity-like forms of adjudication or arbitration, either in conjunction with equity's jurisdiction or outside of it. Further, flowing from this remedial capability is therefore the potential for the creation and amplification of property rights and interests by DLT akin to those defined in and by equity. DLT may work or are already working in closer harmony with systems and procedures in equity than with other laws or areas of legal competence, and are doing so on behalf of the evolution and expansion of property rights and interests. A more extreme view, of course, and one I've already hinted at, is that DLT has the potential to, or has already begun to, supersede equity's jurisdiction altogether. But I'm not going to argue that position here in the paper. Perhaps that's something that we can discuss, and I think has sort of flared up in some of the papers that we've heard today already. So to address these ideas, speculations, or perhaps threats posed by the potential for growing overlap between DLT and equity, I offer a broad idea of performance engines that could encompass a wide range of DLT operations and use cases. But to help understand the significance of performance in this techno-equitable setting, I want to draw on some of my previous more specific work on smart contract design, which I've elsewhere highlighted as privileging performance to the detriment of classical contract law and theory. In some respects, my discussion here challenges my earlier thinking on this subject. For instance, instead of describing a failure in smart contract design to reasonably account for the importance of remedy in contract law and theory, thereby bringing into question the legitimacy of smart contracts as legally valid contracts, it's precisely the nature of smart contracts, DLTs, and blockchains as perpetual scripts or protocols capable of guaranteeing performance, as equity might and in many respects does, that interests me. To start, however, I want to consider a couple of recent and significant cases that highlight, among other things, the matter of performance of ordering a defendant to do something as this intersects crypto assets, DLTs, and equity. So first, I want to look at Justice Jandal's comments in the recent New Zealand case of Rusco and Cryptopia from 2020, where it was concluded that crypto assets were property for the purposes of the distribution of assets in liquidation, and what is systematically and conceptually at stake from this analysis for the mutual performative functions of DLT and equity. Specifically, I want to focus on paragraph 127, section B of that judgment, which informed some of my thinking on today's topic, where Justice Jandal, arguing that, quote, cryptocoins are no mere information than the words of a contract are, end quote, then concluded that what allows a contract to be capable of being property is not the words nor even the binding promise, which is only a personal obligation, but the fact that equity recognizes there is a unique relationship between the parties created by the words and then supplies a system for transferring the contractual rights. Similarly, a unique relationship and system of transfer exists with respect to the relevant data on the blockchain that makes up a crypto coin. So to my mind, it's this association made between equity's system of transferring rights and the system of data transfers on blockchain that points us, or starts to point us, potentially towards the idea of the performance engine. But the case concerned the liquidation of Cryptopia, which was formed in 2014 as a cryptocurrency trading exchange, following a hack in May 2019, where the company lost $30 million of cryptocurrency. The case doesn't actually make it clear whether they're talking about New Zealand dollars here or whether it's US dollars, but $30 million of cryptocurrency. Two key questions came before the court on behalf of liquidators. So first, what exactly the assets in liquidation were, and second, how ought those assets be distributed? So in reaching his conclusion that the crypto assets were property and therefore capable of forming the subject matter of a trust for the purposes of distribution back to Cryptopia's account holders as beneficiaries, Justice Jandal paid particular attention to, quote, a diverse range of types of assets that have already been recognized elsewhere as property at equity. Further, he followed closely the reasoning set out in the Law Tech Delivery Panel's legal statement on crypto assets and smart contracts, the statement drafted on behalf of the UK Jurisdiction Task Force, which, among other recommendations, had concluded that a crypto asset is, quote, a conglomeration of public data, private key, system rules, end quote. And just sort of as a side note here, especially as Nathan was talking and trying to work through this idea of intangible object, or as perhaps digital objects, I think this particular description of a potential property object, crypto asset as a property object, as this conglomeration of public data, private key, and system rules is sort of an interesting way to problematize, perhaps further, some of the more clean-cut understandings of property that we are dragging into the digital realm. So it's important to point out at this stage as well that the Law Tech Delivery Panel statement had also been influential in a case immediately before Cryptopia. So my second case is AA and Persons Unknown from 2020, which involved a claim by an insurance company that had paid a ransom in Bitcoin on behalf of one of its customers following a ransomware attack on the customer's IT systems. The insurance company sought an order of interim proprietary injunction in respect of the Bitcoins held in the account of the fourth defendant, Bitfinex, who operated a cryptocurrency exchange registered in the British Virgin Islands. As with Cryptopia, a key question for the court was whether crypto assets were property for the purposes of the remedy. Justice Bryan, following the criteria set out by Lord Wilberforce in National Provincial Bank and Ainsworth in 1965, as well as the guidance of the Law Tech Delivery Panel statement, concluded that cryptocurrency was property capable of being the subject of a proprietary injunction. Moreover, following Lord Brown Wilkinson in Westdeutsche Landesbank 1996, the property obtained by fraud enabled constructive trusteeship to be imposed on the fraudulent recipient, meaning the property was both recoverable and traceable in equity. So, two cases, both dealing as a matter of procedural necessity, but equally claimant desire, with the issue of finding crypto assets as property for the purposes of unlocking the performative and flexible benefits of equitable remedies. And as Justice Bryan maintained in AA and Persons Unknown, quote, "I'm satisfied that damages would not be an adequate remedy in circumstances where the 96 Bitcoins could be dissipated. And I'm satisfied that the insurer has a strong claim to the Bitcoins in question. There may be also something to say about the desire for the Bitcoin over damages because of the possibility that the value of the Bitcoin would easily and quickly surpass the damages awarded by the court, especially given Bitcoin's present bull market status." And apologies, that end bit was me, that wasn't Justice Bryan. So could the accrual of the value of the Bitcoin held on constructive trust under the terms set out by Lord Brown Wilkinson and Westdeutsche be classed as simple interest? Justice Bryan doesn't deal with that matter in AA and Persons Unknown, although there is brief mention of Lord Brown Wilkinson's approach, and it hints at his stolen bag of coins analogy from Westdeutsche, and therefore interest that starts to run from the date of the upfront payment, which in terms of Bitcoin could be a significant sum, and perhaps, and that in itself could be reason for the courts to think twice about such interest payments with regard to crypto assets. I think this is going to be an interesting test of this in the next, well, in the coming years, certainly as we're seeing Bitcoin become more and more mainstream and several other tokens and crypto assets following closely behind. So equitable remedies were viewed as the best option for claimant and court in both cases, because the aim was getting the defendant to do something with the crypto assets, namely to hold them with a view to returning to the claimant rather than the claimant settling for damages. Performance was key, therefore, and what's more, we see it interlaced with an emerging sense of crypto assets, defined, we'll recall, as a conglomeration of public data, private key, and system rules, as falling somewhere between tangible and intangible property, at once things in action and possession. And so on this latter definition, and responding in part to Nathan's paper, this is what I was scribbling down while I was listening to Nathan's paper. There has been the suggestion made in a 2016 article in the Journal of International Banking and Finance Law that crypto assets have attributes of sharing certain characteristics of both intangible property and shows in possession, meaning that there may be an argument for extending the traditional legal categories to recognize virtual shows in possession as a new form of property. This was actually rejected as unnecessary in the case law that I've already mentioned, but not really with sufficient reason. It was kind of, the idea was sort of brushed aside as just simply not necessary. So perhaps I suggest there is still plenty of work to do here, and I think listening to Nathan's paper in particular takes us on a sort of an interesting journey into that realm. So earlier I suggested that we might speculate on the equity-like function of DLTs as one possible response to the question of how control exists after decentralization, or how control endures within distributed networks with shared protocols but no other meaningful or enforceable points of contact, no interoperability. The performative assumptions that equity makes, which can be summed up succinctly in the maxim equity treats as done that which ought to be done, when translated into the sort of technological domain I've described above, are arguably free to do away with the suggestion or encumbrance of moral imperative. There is, in other words, no room or need for ought in the transactional operations of a performance engine. Morel-Hildebrand implies a similar issue in the shift from performative to performative oral or written speech acts that cannot be achieved by computer code. The code has different affordances, claims Hildebrand, and doing things with words is not one of them. But, she concludes, this does not mean that computer code is not capable of forcing or luring people into specific behaviors. On the contrary, many automated decision systems are very good in doing just that. They remain, however, in the realm of perlocutionary acts, which means that the effect they have is causal rather than constitutive. They generate a rule of machines instead of a rule by law. The DLT ecosystem and the forms of control it demands are more brutal in this sense. And Justice Gentill said of cryptocurrencies in the Cryptopia case that the whole purpose of them is, quote, to create an item of tradable value, not simply to record or to impart in confidence knowledge or information, end quote. And the wide-ranging application of the maxim mentioned a moment ago apply not only to contracts, but also, for instance, to bribes held in breach of fiduciary duty, shows us the potential for performance engine implementation that is geared towards a world of amoral transaction that equity has long been immersed in. We must not overlook, however, the fact that stripping away characteristics of equity to realize the equity-like performative capabilities of DLT causes issues. Morel-Hildebrand says more broadly of the potential for data-driven legal systems, quote, we may lose the mode of existence of law where legal protection is part of law's instrumentality rather than an add-on. Because this instrumentality is built on legal effect rather than merely brute force, and because legal certainty thrives on the contestability of facts and norms, not on the mechanical application of logical rules, end quote. And here I want to turn to my work on smart contracts, where I've previously argued that designers or engineers can make smart contracts appear at once intelligent and legally legitimate without them really being any of these. They do, as Hildebrand might suggest, apply mechanical and logical rules without leaving room for the contestability of facts and norms. J.G. Allen echoes this analysis when he claims that, quote, many of the software processes currently hailed as smart contracts are indeed more accurately described as performance mechanisms. Equity is key because smart contracts programmed to send or collect sums of money or transfer value will unquestionably do so. And the identification of funds and rights, and ultimately the recovery of value, therefore, in whatever form that prevails, whether it be fiat currency, cryptocurrency, or tokens, will be a priority for claimants over mere damages or compensation. We've already seen that in AA in persons unknown. The smart contracts could therefore herald a turn to equitable remedies as the most effective remedies for electronic machine-enabled transactions that do not fulfill the intentions of the parties. This remains untested by the courts, to my knowledge, but given the role played by injunctions and constructive trusts in the cases mentioned earlier, it is a reasonable assumption to make. Specific performance enables informants of an agreement for which money, damages, or compensation does not suffice. To undermine or dismiss remedies rooted in performance seems incongruous in a world of smart contracts, because the one thing smart contracts almost always guarantee is performance. Yet the mere fact of their insistence on performance does not mean smart contracts solve the problem of a suitable remedy for situations in which monetary compensation is not suitable or desirable. Equity, as Sarah Worthington points out, develops specific performance because the monolithic approach of the common law to contracts became inappropriate and ignored the relativities that society attached to different contractual rights. Smart contracts don't change or alter this concern, but as I've argued elsewhere, if allowed to sidestep performance-based remedies in equity, they do threaten to undermine contractual rights further. However, with the concept of a performance engine, there is potential to reimagine, redefine, possibly recalibrate the smart contract operating system, namely the DLT or blockchain, to ensure it's capable of fulfilling equity's emphasis on performance in techno-transactional domains. Courts aim to uphold contracts when and where possible, but this is not always desirable on the facts. And such processes show that contract is flexible, contingent, and perhaps above all else, a reflection of the inherent messiness of human enterprise that leads all too often to mistakes and frustration of agreements. This, for some technologists, may be reason enough to find a solution to the problem of traditional contract law. But it's incumbent on smart contract designers to remember that contracts exist not only in an immature state like vending machines, for example, nor is it desirable for contracts to do so if a balance between the express and the consensual execution of rule-based agreements and the moral obligation of promise and performance is to remain intact, both central tenets of legally binding agreements. So just to conclude.
It's a 3-minute warning, so good timing, Rob.
Perfect, Nick, thank you. So just to conclude, the problem of bridging real and virtual worlds and bringing laws into digital harmony remain major obstacles for DLT operating systems and the operations they could potentially impart or commit. Hence, whether we ought to see smart contracts as contracts at all remains open to debate. We might understand smart contracts instead as a piece within the larger jigsaw of domestic and international contract law, rather than an alternative to or a replacement for traditional contracts. By extension, we may consider DLT a performance engine capable of working in harmony with equity to foster equitable outcomes. As the Law Tech Delivery Panel's statement puts it, quote, "In no circumstances are there simply no legal rules which apply," end quote. And in equity, I suggest, there is an opportunity to test the legitimacy and efficacy of the new technological systems, networks, and protocols that will shape the future. Thank you very much.